Hey guys, good morning. Hannah Bell, family lawyer, here with Family Law 101, the parking garage edition. I'm like doing this real quick before I go into a training, but I thought it was kind of fun because look, you can see Austin skyline over there. It's kind of neat. But okay, if you remember, we're doing this whole little series, little mini series, not the Lifetime movie kind, but the family law kind, which sometimes looks like a Lifetime movie kind. And first we talked about what are temporary orders, like what does that mean? How are they relevant in the family law context? Now, next we're going to talk about how do you know if if a temporary orders have been set in your case. So that's going to happen in one of two ways, right? First, you're going to find out because it comes in that initial paperwork whenever you get served. So remember we talked about you're going to get this packet and you might see on the first couple of pages something that says you are hereby ordered to appear at this date, at this time, at this court. That's where it's going to talk about temporary orders. Because you see, if the lawyer wants to set a temporary orders hearing within your 20-ish days to answer, they have to get the court's permission to order you to appear before the time to answer. So they're going to include it in that initial stuff. So if it doesn't say you're ordered to appear, then you don't have to appear if it's before the time to answer. Okay, so first, it could be that initial packet of paper. So if you see that, like, get a lawyer, for sure. Mark it on every calendar, set a reminder on your phone, whatever. It's time to get going and it can happen pretty fast. I mean, you need minimum 3 days notice. So, I mean, from like a Monday to a Friday, right? You can be at a hearing. Okay. So number one, it could be in that initial packet of papers when you get served. Number two, some lawyer is gonna tell you if there's the lawyer who filed the papers on the other side anyway. Because obviously if you're doing the temporary orders, you're gonna be making that decision in connection with your lawyer. You're gonna know what day, what time, you're gonna pick it, all that. But if you're on your own and you're representing yourself, if it doesn't come in that initial paperwork, the lawyer still has to give you at least 3 days notice that it's coming. So they're going to either email it to you, mail it to you, call you, something or another to let you know. Now, when you say, how do I know if it's 3 days notice? I always thought this was a little hard. So the day that you become aware of something is day 0, and then you count 1, 2, 3. And the third day, at least in Bexar County and Travis County, I think most of them, you can count the day of the hearing. So say Tuesday, you found out about the hearing. So that's day 0. And then Wednesday, Thursday, Friday's day 3. So from Tuesday to Friday, I mean, that is fast. So the temporary orders mini-series part 2, how do you know if temporary orders are set? Either they're gonna be in your initial paperwork or some lawyer's gonna tell you. Now, the other thing you can do, sort of belt and suspenders, and I would probably advise doing this if you're not having a lawyer, is you can call the court, the presiding court, and say, hey, has anything been set in my case? Are there any pending hearings? And in San Antonio, wait till 2 o'clock the day before. So you could just 2:30, if you think they're coming, 2:30, set a little thing on your phone and call and say, hey, is there anything set in my case or with my name or whatever, and figure that out. And you can also call the clerk in Travis County to double check that something hasn't been set. Because remember, they can go forward without you if you don't show up and you have proper notice, and they can show that. So, all right, part 2. Hope everybody has a great rest of your week.